Good evening. My name is Ted Ruger. I'm the Dean of the Penn Carey Law School at the University of Pennsylvania, and it's a pleasure to welcome you this afternoon. On behalf of the law school and our colleagues at the Center for Africana Studies, welcome to the 2021 Honorable A. Leon Higginbotham Jr. Memorial Lecture. This annual lecture, which honors the legacy of Judge Higginbotham, is co-hosted by the Center of Africana Studies and Penn Carey Law School. I'm very grateful to Professor Margot Natalie Crawford, who's a professor of English at the university and the director for the Center for Africana Studies, for her partnership on this lecture and other programming this year and in other years, as well as our other colleagues in Africana Studies and across the university. We're delighted today to virtually welcome Professor Tomiko Brown-Nagin to present this year's Higginbotham Memorial Lecture. I'll more properly introduce our speaker, as well as my colleague, Professor Anita Allen, who will serve as discussant in a moment. But first, wanted to hit a couple of introductory matters. Welcome the many of you who are alumni, and some of you working attorneys in the audience and members of the bar who are interested in continuing legal education or CLE credit. We're going to announce CLE passcodes twice during this event, the first in a moment, the second at 5:30 at the end. Please write down these codes and enter them on your digital evaluation form once the event is over in order to get credit. The evaluation form is mandatory to receive CLE credits. The first password is QUEST, Q-U-E-S-T, befitting Judge Higginbotham's quest for justice that is still continuing. So yeah, the password is QUEST. The format for this event is a distinguished lecture from Professor Brown-Nagin, followed by commentary and questions led by our distinguished colleague Anita Allen, who will include some audience questions during that period. To submit a question, use the Q&A feature at the bottom of your Zoom screen. That's different than the chat feature that we're all Zoom veterans now, a year and a half in, but so this is not Zoom chat. It's a separate tab called Q&A. And Professor Allen and Professor Brown-Nagin will, and we will try to get to as many questions as possible within our time constraints. Please keep your questions topical and appropriate. We are recording this webinar, and we're going to post this recording on the law school's YouTube channel for later viewing, if you'd like. Third and most important, substantively, this lecture honors the prodigious and important legacy of Judge Leon Higginbotham. Both speakers who are going to follow me are going to say more about the judge's immense influence nationally and in this community and on this law school, where he was on our board and an important teacher and supporter and mentor to so many students and faculty members over several decades. I know how important he was to this law school, and you're going to hear more from the speakers that follow me about that importance, but certainly I'm grateful to honor him here. I did want to say this with tremendous enthusiasm and excitement. This is the first of several ways we're going to honor the judge and his career in the upcoming year. And we're really grateful to be partnering with this really successful Philadelphia Mural Arts Program. Those of you who are in Philadelphia and you see over the past decade or two these murals around the city. They're going to do one on Judge Higginbotham. We're helping support that both with research and financially. It's going to be in West Philadelphia. I think they haven't yet found the exact wall it's going to be on, but it'll be, like the judge, far greater than life size, and really honor his legacy and his history and his connection to this community. And so we'll have some more events in the spring, probably with the artist and with some of our students and alumni providing some research and reflections, and then we hope, if it stays on schedule, a big unveiling next summer or early fall, and then an additional way that we can honor the judge in the community. So please look for that. It's now my great privilege to introduce our distinguished speaker and a distinguished colleague who's going to serve as discussant. And I'm going to be, they're both eminent and distinguished, and in order to get to them sooner, I'm going to be quite brief and only draw selectively from their prodigious CVs. But first, really happy and honored to have Tomiko Brown-Nagin, who is Dean of the Radcliffe Institute for Advanced Study and the Daniel P.S. Paul Professor of Constitutional Law at Harvard Law School, Professor of History at Harvard University as well, as our distinguished Higginbotham lecturer this year. Dean Brown-Nagin is an award-winning legal historian and an expert in constitutional law, education law, and policy, as well as the history of the legal profession, befitting, I think, what we're going to hear about today, and situating Judge Higginbotham and other leading figures of the civil rights movement as lawyers, as leaders. And her work has been cited and published in numerous books, book chapters, and she's an expert in the Supreme Court jurisprudence. She's published in all the top law reviews. Her 2011 book, Courage to Dissent, Atlanta and the Long History of the Civil Rights Movement, won the Bancroft Prize, the highest prize in U.S. history. And she's currently at work on a book called The Civil Rights Queen, about the life and times of the Honorable Constance Baker Motley, who was a leading lawyer, politician, and judge during the civil rights movement. And that will be coming out in a few months, I think. And I suspect we'll hear about some of that research contextualizing alongside Judge Higginbotham and that era tonight, and I'm excited about that. I had the personal pleasure of being a colleague of Professor Brown-Nagin's when we were both beginning our careers at the Law School of Washington University in St. Louis, so it's very good to welcome you, at least virtually, tonight. And I'll, with appropriate vagueness for the audience, I'll say that was sometime in the 21st century. It was long ago, but at least it was this century when we were together as young law professors. So welcome, and it's great to see you virtually at the University of Pennsylvania. Joining me in welcoming Dean Brown-Nagin and leading our discussion tonight is the eminent colleague, Professor Anita Allen, who's the Henry Silverman Professor of Law. She's a professor of philosophy at the university and a leader in both fields. We're very happy to have Professor Allen back as a full-time law school colleague. She recently ended a successful and important and long tenure, as longest in this university's history, as vice provost for the faculty for the entire university, where she led and led us overall in the university in great strides in terms of equity and diversity on our faculty. And it's great to have you back with us full-time, Anita. Professor Allen is an internationally recognized expert in privacy law, ethics, legal philosophy, women's rights. I could go on, but is eminent, world-renowned and nationally renowned. Among her many high-level posts and honors, she served on President Barack Obama's Presidential Commission for the Study of Bioethical Issues. A pioneer in her own right, Professor Allen is uniquely qualified to say more about Judge Higginbotham's pioneering role, both nationally and locally and here at the university. And Anita, I turn it over to you with gratitude, as well as you, Professor Brown-Nagin. Thank you.
Thank you very much, Dean Ruger. It's a real pleasure to participate once again in the annual tribute that the University of Pennsylvania pays to honor the memory of Judge A. Leon Higginbotham, Jr. The event is a collaboration between the Africana Studies Center and the School of Law. And I want to thank Professors Camille Charles, Margot Crawford, and Barbara Savage for their historic contributions to the center, and also to them and Professor Michael Hanchard for their leadership of the Africana Studies Department. Penn faculty members who are affiliated with the Africana Studies Department include Dorothy Roberts and myself, and I know that we both value our relationship with the School of Arts and Sciences as a sign of the interdisciplinary character of the Penn Law School. Like our speaker this evening, Dean Tomiko Brown-Nagin, in his day, Judge Higginbotham was a historian and a trailblazer. Brown-Nagin's career as a trailblazer has in many ways just begun. We expect decades more trailblazing, and I'm looking forward in particular to her latest book, which will come out early next year, about the life of the Honorable Constance Baker Motley, a civil rights lawyer, a politician, and a judge. Let me mention just some of the highlights of the life of Judge Higginbotham. He had quite a life, especially given the era in which he was born. He graduated from Antioch College in 1949, Yale Law School in 1952. He was a Philadelphia County Assistant District Attorney, a partner in a law firm called Norris, Green, Harris, and Higginbotham in Philadelphia, and a special hearing officer for conscientious objections to the U.S. Justice Department. He was also a commissioner of the Pennsylvania Human Relations Commission. All of these accomplishments happened in the 50s, 60s, long before it was commonplace for African Americans to hold such high positions of leadership. Notably, Judge Higginbotham was the very first African American to be a commissioner on the Federal Trade Commission, and in that role led some important innovations and initiatives. He then, of course, served as judge the District Court of the Eastern District. He was vice chairman of the National Commission on the Causes and Prevention of Violence, and then became judge for the District Court in Virgin Islands, and then on the Court of Appeals, U.S. Court of Appeals for the Third Circuit. He was later counsel to Paul Weiss, Rifkin, and Wharton. He was a professor at the Harvard Kennedy School in the 1990s, and an international mediator in the 1990s of the first South African election in which blacks were allowed to vote. In 1978, and this goes to his role as historian, Judge Higginbotham wrote a remarkable book called In the Matter of Color, and it was about the early history of American slavery. It's the only book I've ever read that literally brought me to tears. I often wondered about the title of the book, and then when I read the book, I understood the title. It comes from an experience that Judge Higginbotham had as a student where he was briefly at Purdue University. And this is what he said about that experience. He says, as I write this preface, as I write, I see an America that is still struggling. This is 1978, that is still struggling. But I also see an America that's made extraordinary strides since the night I was told by President Eliot at Purdue University that I should pack up my bags and leave the university if I could not accept that it was simply a matter of color that I had to sleep in an unheated attic instead of the heated dormitories with the white students. That experience inspired the judge to become a lawyer and inspired him to work for civil rights and work for equality, because it's been all too often in this country a matter of color. We're still struggling. We were struggling in 1978 when the judge wrote those remarks, and we're still struggling today. And today's lecture by Dean Tomiko Brown-Nagin is a part of that struggle as we become more and more sophisticated in our understanding of the legal profession, of civil rights. We're honored to have one of America's most important voices on the history of civil rights here with us this evening. So let me turn the floor now over to Dean and Dr. Brown-Nagin. And by the way, there'll be an opportunity for question and answers afterwards. Please write your questions in the Q&A as you have them during the lecture. Thank you. Dean?
Thank you so much for that kind introduction, Dean Ruger. It is a pleasure to see you again. As the Dean mentioned, we go way back to about 2004 when I began my career in law teaching. I also want to say thanks to Professor Allen for being a part of this event. I have long followed her scholarship and her leadership, and it's a pleasure to share the stage with you. And thanks to the Africana Studies Center for the invitation to be here this evening. It is a distinct pleasure for me to give this lecture in honor of A. Leon Higginbotham, one of the greats. And I want you to know that Judge Higginbotham was a part of one of my most memorable experiences as a law student. After my first year of law school at Yale, I worked for the Lawyers Committee for Civil Rights in Washington, D.C., and I was thrilled to have this opportunity. I had hoped to work in civil rights since I was a young girl, and I saw this internship as a step along the way to my dream. And I have to tell you, the experience did not disappoint. Not long after I started that summer, the Lawyers Committee hosted a conference, and there were superstars in the field there. Barbara Arnwine, who of course was head of the Lawyers Committee, spoke. So did Elaine Jones of the NAACP Legal Defense Fund, and then there was Lonnie Guinier, the law professor who had written so compellingly about voting rights, and after her career at Penn Law became the first African-American woman on the faculty of Harvard Law School. And for a student like me, who had grown up in the Deep South, where the reality of racial injustice was present every day. These lawyers were exalted figures. They were luminaries, celebrities. And Judge Higginbotham gave the keynote address at that conference, and he mesmerized the crowd. I can remember it as if it was yesterday. The judge standing on the stage at the lectern, his tall frame erect, his eyes peering over his glasses, raising his deep baritone voice. Anita Hill called it the voice of God, and I agree, with great passion. And he, during that talk, was demonstrating the extraordinary verbal talent that one of his Yale Law School professors had recognized many decades before. And during that address, Judge Higginbotham exhorted the audience, and he did so not unlike, in my view, a learned pastor would exhort his flock. And he invoked the themes that led Supreme Court Justice William Brennan, one of the court's liberal lions, to call Higginbotham the conscience of the legal profession. And on that day and on many other occasions, Higginbotham argued that the legal profession was special and African Americans within it, including judges, should be deeply concerned about and speak out against racial bias. They ought to be a voice for the voiceless and lift up the humanity and dignity of all people. And I'm quoting him. The job of a minority judge is to be very much concerned about aspects of the system that work harshly against Blacks and others who've been historically treated unfairly by the system, because if minority judges do not speak up, it gives an imprimatur of satisfaction and approval. The judge urged those cloaked with legal authority to speak out, because the marginalized have a hard time being seen and heard, having their stories heard in America. And of course, this is particularly true of descendants of enslaved people in America, as the judge well knew, given his work in the matter of color, where he wrote that the poisonous legacy of legalized oppression based on color during slavery could never be adequately erased from our society. Being seen and heard is critical to a fair shot in life and a fair hearing in court, where the lives and liberties of individuals often hang in the balance. Judge Higginbotham endorsed empathy, the capacity to see the world from the perspective of another, in this case, those on society's margins. And he did so long before empathy became a trendy topic in the law reviews. Now, there are many who argue that equitable lawyering and equitable judging require active listening to litigants. And really listening to someone requires empathy. And this is particularly true when there's a power disparity and when a person is from a marginalized community and seeking a hearing. A lack of empathy can lead to bias or indifference to others. Now, President Obama, maybe you remember him, deeply believed in the connection between empathy and fairness. Standing on the shoulders of pioneers like Judge Higginbotham, Obama repeatedly urged us as a body politic to embrace empathy. In fact, he was fond of saying that Americans had an empathy deficit. And he said, I'm quoting, "The most important thing we can do is to look through somebody else's eyes." Obama famously endorsed the value of empathy in judicial appointees, saying, we need somebody who's got the heart, the empathy to recognize what it's like to be a young teenage mom or poor, African-American, gay, disabled, or old. And that's the criterion by which I'll be selecting my judges. Justice Sonia Sotomayor, who had hoped that a wise Latina woman would, more often than not, reach a better conclusion than a white man who hasn't lived that life, of course, fit the bill. Now, Obama's endorsement of empathy and Sotomayor's statement were quite controversial in some quarters, as you may recall, with stories and headlines all over the newspapers. And so the question is, why did these public figures advocate empathy? I would say that for Judge Higginbotham, no less than for Sotomayor and Obama, the call to conscience was rooted in a humble background, in the judge's own life experiences of poverty and discrimination, and the experiences and teachings of his parents. And I was captivated by many of the stories that one can find about Judge Higginbotham and growing up, one of which had him remembering that he once was working as a busboy in a hotel. And he recalled his mother saying to him, "Son, I don't want you to be a busboy all your life. I don't want you to do the things I've always done, washing other people's dishes, cleaning other people's toilets, and scrubbing other people's floors." For his parents, from his parents, Judge Higginbotham learned to dedicate himself to his community by extending a helping hand to the less fortunate. And as Professor Allen said, he was drawn to the law, hoping to use it as a tool of change. He recalled, quote, "I went to law school for one reason, and that was that law was a powerful instrument. I felt that justice could overcome anything." And his various jobs in the private and public sectors, including his appointments to the judiciary, provided a platform and an opportunity for him to realize that aspiration. Now, it wasn't enough for Higginbotham to believe in and live these values himself. He urged his mentees, practicing lawyers, and even judges to do the same. And here's a great example of Higginbotham pressing the case. In 1987, in the pages of the Harvard Law Review, the judge wrote that today's lawyers should move beyond technical competence to moral and social commitment. They should be legal architects who renovate the Palace of Justice and redesign the landscape of opportunity in our nation. They should commit themselves to pursuing their moral visions. And of course, he famously took to task Clarence Thomas, who, after what we'll call an eventful confirmation process, ascended to the Supreme Court, taking the seat once held by Thurgood Marshall. Higginbotham exhorted Justice Thomas, who had grown up poor and Black in Penn Point, Georgia, to recognize the force of history within you, quoting James Baldwin. Black judges like Thomas should never be blind to Black suffering and to the consequences of sanctioning violence or racism. They should seek to fit the mold of Justice Thurgood Marshall, who of course viewed the law as an instrument of justice. Now, but that's not all the judge said. On other occasions, Judge Higginbotham complicated his views on race and judging. In 1992, a year before he retired from the bench, he said Black judges had no special role to play on courts. Like other jurists, they must base their decisions on relevant facts and law. And he described his judicial practice as follows: "I don't write Black opinions, I write Black letter opinions." Moreover, Higginbotham lamented the identity-based scrutiny that African-American jurists face. He said Black judges do bear burdens that white judges do not. In particularly, Black judges were continually monitored, he said, in race-sensitive cases. Some people will question a Black judge's impartiality. Now, he is far from the only Black judge to make this point. Many of the first wave of appointees said much the same. Take as another example, Robert Carter, second in command to Thurgood Marshall at the Legal Defense Fund, general counsel of the NAACP, appointed to the district court in 1972. Carter was enraged, and I mean enraged, I clerked for him, I know, with what he called the recurrent question, can you be fair to white people? It was posed by bar committees and senators considering his judicial nomination. Now, later on in his memoir, after he'd secured that judgeship, he wrote, the more pertinent question considering history was whether white candidates could be fair to Blacks. A similar burden extended to Black women. Constance Baker Motley, the first Black woman appointed to the federal bench in 1966, knew that burden. She took her seat on the bench after a long career in civil rights practice at the Legal Defense Fund. She was a protege of Thurgood Marshall and a colleague of Robert Carter. She too endured a delayed confirmation vote and repeated motions for her recusal from certain cases because of that burden that Higginbotham identified. And here's the thing, the very figure of a judge, the image that many people summon when they think of a judge is all bound up with race and gender and so many other categories. The normative judge is heterosexual, middle class, a white male, probably from private practice. In other words, socially and economically dominant. And to hearken back to the words of Judge Carter, the reality is that the fairness of white candidates typically is assumed. And that brings us to the overarching point. Against the backdrop of this special burden, the call to conscience to Black and outsider judges presents a conundrum. And that is how to reconcile the identity-based command of empathy for the marginalized with the professional norm of impartiality. Now, this precept, which is represented in this familiar depiction of Lady Justice with the blindfold, is said to be fundamental to the rule of law. It's the idea that justice should be blind, rendered without regard to wealth, race, sex, or any other background characteristics. This idea animates the legal profession in the West and has for some time. Therefore, empathy and impartiality would not seem to be a good fit. Now, let me say this. I'm going to go with this blind justice idea to make a point, but I do want to say that there are many data points that illustrate that this precept is a myth, predicated on historical amnesia about law's role in society as it relates to race and so many other categories. After all, was justice blind during the era of slavery? Well, Justice Higginbotham, a superb scholar as well as a lawyer, told us that it was not. He explained in his book, In the Matter of Color, what I show is that the law itself, the courts, not merely reflected people's prejudices, but actively led them. And the impact of slavery and the vestiges, its vestiges has lasted for generations, only yielding as a result of the great social movements of the mid-20th century. Thurgood Marshall knew this. In a 1987 speech at a bicentennial celebration of the Constitution, which was meant to highlight, quote, the wisdom, foresight, and sense of justice shared by the framers, Justice Marshall offered what the New York Times called a critical reflection. What he truly did was to reveal the painful truth about the nature of law and its role in the lives of African Americans over time. He said, "I do not find the wisdom, foresight, and sense of justice exhibited by the framers particularly profound. To the contrary, the government they devised was defective from the start, requiring several amendments, a civil war, and a momentous social transformation to attain the system of constitutional government and its respect for individual freedoms and human rights that we hold fundamental today." And of course, some listeners were not happy with Marshall's address. Nevertheless, it was, in fact, a truth. Now, the justice is blind narrative also rests, I have to say, on a simplistic notion of how the law actually works. The words of legal text, from the Constitution to statutes to regulations, require interpretation and reconciliation with precedent. Recall Justice Story saying that the Constitution unavoidably deals in general language, and Chief Justice John Marshall famously writing that we must never forget it is a constitution we are expounding, a framework. Just judicial decision-making is an art and a craft more so than a science, although certainly there is a method to that art. Now, notwithstanding the facts about the nation's history and the artfulness of the legal method, this commitment to impartiality is a powerful organizing force, because narratives need not be precisely true in order to be pervasive and persuasive, which brings us back to this conundrum. Because so many observers assume that identity, whether race, gender, religion, sexual orientation, and other aspects of one's background, in fact, does matter, or can matter at least, in legal decision-making, judges deem empathic, because of a self-proclaimed commitment to empathy in the manner of Judge Higginbotham and others, seem to call into question this core commitment to impartiality. For as the scholar Susan Bandas has written, the notion of empathy in judging appears to conflict with the ideal of the rule of law. This tension between empathic judging and impartiality can delegitimize judges of color, even if they are not as bold as Higginbotham on the role of empathy in judging. In fact, judges of color frequently have been the targets of motions for recusal on grounds that their background characteristics or their demographic characteristics called into question their ability to be impartial. Litigants challenged the integrity of several Black judges who practiced in the field or even simply endorsed civil rights. That list includes Judge Higginbotham, Constance Baker Motley, Robert Carter, Nathaniel Jones, Damon Keith, among others. And this phenomenon, I must say, persists. Litigants still single out for recusals judges who are of color, female, gay, outsiders, and so forth. Now, I want to illustrate that this point that impartiality is all bound up with race, gender, and experience by pointing to one of Judge Higginbotham's best known opinions. Well, early in his career as a district court judge in 1974, Judge Higginbotham was asked to recuse himself from a hearing in a racial discrimination case because he had given a speech to the Association for the Study of Afro-American life and history, decrying America's history of discrimination. The defendant viewed Judge Higginbotham as an African-American versed in Black history and committed to Black freedom as likely to be partial to the African-American plaintiffs. Well, the judge rejected this request in an opinion that was a tour de force. In a section of his opinion labeled "Being Black," he wrote in part, "I concede that I am Black. I do not apologize for that obvious fact. I take rational pride in my heritage, just as most other ethnics take pride in theirs. However, that one is Black does not mean ipso facto that he is anti-white, no more than being Jewish implies being anti-Catholic, or being Catholic implies being anti-Protestant." Moreover, he insisted that his recusal would amount to a double standard within the federal judiciary. Under this standard, if a Black judge, and only a Black judge, discussed race relations, he should be precluded from adjudicating matters involving claims of racial discrimination. And so through a series of rhetorical questions, the judge showed that this was absurd and uniquely discriminatory. And he concluded in that powerful opinion that the plain truth is that white litigants are now going to have to accept the new day where the judiciary will not be entirely white, and where some Black judges will adjudicate cases involving race relations. It was a brilliant opinion, but it did not stop litigants from continuing to file these recusal motions against Black judges or female judges, or in the improbable case of a Black female judge, such as a first, Constance Baker Motley. Let me tell you about one of these motions. It was a sex discrimination case filed against Sullivan and Cromwell by several female law school graduates in 1975. And in this case, Motley's race and sex explicitly figured into calls for her to withdraw from the case. The law firm's attorney protested after Motley drew the case. In a letter to the judge, and then in a formal motion, he requested that Motley recuse herself because, and I'm quoting, "as an African-American and a woman, she likely had experienced workplace discrimination." And he also cited a past statement that Motley reportedly had made regarding, quote, "the crippling effects of discrimination." Given her identity and experiences, Motley would strongly identify with other women who alleged discrimination, he said. And quoting again, "I believe you have a mindset that may tend, without your being aware of it, to influence your judgment." And so he argued, by implication, that only white men could properly preside in a sex discrimination suit of this nature. Now, Motley would not recuse herself from this case. After analyzing the Black letter law on judicial recusal, she directly addressed the heart of this attorney's allegation, saying, "It is beyond dispute that for much of my legal career, I worked on behalf of Blacks who suffered race discrimination." And moreover, she said, "I am a woman, and before being elevated to the bench, was a woman lawyer. However, these facts did not and could not by themselves rise to the level of bias within the meaning of the relevant law. Quote, if background or sex or race of each judge were by definition sufficient grounds for removal, no judge on this court could hear this case." So the judge had turned this argument on its head, just as Higginbotham had in his recusal case. All judges come to the bench with a background, experiences, associations, and viewpoints. It was a brilliant opinion, just as Higginbotham's was. And in fact, it is one of Motley's best known opinions, and this is over a 39-year career on the bench. Just as Higginbotham's opinion rejecting a recusal motion is one of his best known opinions. Now, I want you to think about that. The most notable opinions by two of our most celebrated Black judges are, in essence, defending their right to be judges, their professionalism, their competence, their personhood. Now, while thinking on that, one might ask, but what about the substance of the matter? What about outcomes in these judges' courtrooms? Well, Judge Higginbotham ruled in some 650 cases. And what one finds is as he ruled for and against plaintiffs in race-related cases. For example, in a prisoner's rights case, Higginbotham authored an opinion issuing sanctions to end a county's chronic practice of overcrowding in jails, vindicating the plaintiffs. But in a workplace discrimination case filed by a Black male plaintiff, the judge affirmed a lower court's decision ruling against that man. And he explained that the district court's findings were not wrong. He also included what I take to be a telling line in that opinion, saying, and I quote, "Our appellate review process does not always guarantee that the truth is found or that individual justice is done. It merely guarantees that a case is tried and reviewed according to the rules." In truth, as Judge Higginbotham's colleague Ed Becker wrote, Higginbotham never served as a rubber stamp for a civil rights plaintiff or a criminal defendant. He was a centrist judge, respectful of precedent and judicial tradition. The very same pattern holds for Motley, as I explain in my forthcoming book about her. Once on the bench, Motley did in fact issue some landmark opinions implementing the Civil Rights Act, its ban on sex discrimination in employment in particular. But overall, Motley did not reflexively issue liberal opinions in favor of plaintiffs in civil rights cases. The conclusion that I reach in my book about her, the Civil Rights Queen, is similar to what Judge Becker concluded about Higginbotham. I write, a political liberal, Motley is best understood as a judicial pragmatist. Now, for those who know the scholarship on race and judging or on gender and judging, you won't be surprised that these great American judges were hardly radicals on the bench. This scholarship tests the notion that judges yield substantive as opposed to symbolic representation for the communities they are thought to represent. Studies have found no significant difference in the voting behavior of white and non-white judges. For example, Black district court judges do not decide cases differently than white judges and do not support Black issues more often than their white colleagues. In fact, one study found a racial impact in criminal cases, but in the opposite direction than one might expect. This study found that Black district court judges imposed harsher criminal sentences than others. As to the appellate courts, the presence of Black judges on appellate panels does not lead white judges to issue decisions more favorable to Blacks. And here is why. The identity-related empathy that Judge Higginbotham, President Obama, and others have endorsed isn't outcome determinative because judging is mediated by numerous factors, some internal to law, some external to it. The first constraining factor is precedent, which when coupled with the norm of stare decisis, constrains lower court judges. And this is the most important constraining factor. So in that workplace discrimination case that I mentioned above, Judge Higginbotham explicitly noted that his hands were tied because of the standard of review and authoritative law. The same constraints bound Motley and others, And precedent, of course, even constrained at least some justices on the Supreme Court, ensuring that change is most often incremental. Now, a second type of constraint has to do with professionalism and attendant institutional norms. I mean, factors such as collegiality, the desire for respect from the public and colleagues, the wish to avoid overturned decisions, the desire to increase the possibility of promotion. High reversal rates, of course, are fatal to a judge's reputation and to promotion prospects. And Black judges may, in fact, be especially sensitive to at least some of these norms, because in pursuit of professional respect, judges who are subjected to identity-based scrutiny, that burden that Higginbotham identified, might be especially careful to demonstrate impartiality and to avoid using discretion in ways that smack of ideological bias, particularly in cases with a racial dimension. And then there is identity performance. So W.B. Du Bois famously coined the term double consciousness to describe the reality of being an American and a Negro, two warring ideals in one dark body. Decades later, scholars made it even more complicated by describing how gender and other aspects of identity deepen that double consciousness. They coined terms such as multiple consciousness and intersectionality. Even more recently, the concept of code switching has entered the lexicon. I interpret all these terms to acknowledge that identity is relational and performative. I also want to say a word about empathy itself. And that is that it is unlikely to derive from skin color alone. Experience matters a great deal. It is multi-dimensional. Moreover, it has no fixed meaning. It's not confined to those who are especially supportive of oppressed people. One can have empathy for management and investors over labor and consumers, and that could translate into a business-friendly court, as it has. Some have written on the Roberts Court, so much so that Jeffrey Rosen memorably called it Supreme Court Inc. A judge might be empathic towards religious believers or towards pregnant women who might, it is said, come to regret a choice to have an abortion. That's a major line of argument in some of the abortion rights cases, including Casey. Of course, they might have sympathy or empathy for the fetus, for police officers who patrol the highways and so forth and so on. All of which is to say, empathy ultimately does not necessarily get one very far if the point is fairness in courts of law or change through the law. Now, I want to mention a quote from political scientist Ralph Bunche, who wrote in a 1935 article that critically analyzed Black tactics in pursuit of freedom. He argued against over-reliance on the court, saying that the law did not hover like a protecting angel. Rather, it invariably reflected the dominant order, and a judge's sympathy for minority interests should never be assumed. Now, in conclusion, I want to return to where I began, with a law student's sense of wonder at the greatness of Leon Higginbotham and so many other superstars in the field of civil rights. I now know, and I hope this talk has illuminated for you, that in practice, it can be a tremendous challenge to navigate the world as a person committed to justice, particularly as an African-American, and certainly for the few entrusted with the power of the judiciary. But I also know this, as Judge Higginbotham knew. It is deeply meaningful to live one's principles, and to believe in the dignity and worth of all people. And what I believe Judge Higginbotham's life and work teaches us through the many seasons of it as government lawyer, law firm founder, judge, legal historian, public advocate, mediator, is that the pursuit of justice through law requires us to be nimble, multifaceted, creative, personally an open book, and a storyteller. So in closing, I want to leave the adage of a civil rights era protest song with you. It said, "Freedom is a constant struggle." And as Coretta Scott King said, freedom is never really won. You earn it and win it in every generation. I believe that law can be a powerful tool in the enduring struggle for freedom. And this is particularly so, I have to say, if you manage to get yourself on the US Supreme Court with a supermajority for your perspective. I'll stop there. Thank you. I'm happy to take your questions.
Thank you so much for that wonderful, insightful lecture, Dean. And I have some questions for you, and invite people in the audience to add their questions to the Q&A area down below. So one of the things I wanted to ask you is about the absence in your discussion of judicial virtues, the virtue of intellect. And, you know, it's very common to talk about whether the African-American judge brings to the bench special empathy or impartiality or morality or commitment to race or to justice. But shouldn't we also be talking about intellect and not be ashamed or embarrassed that among the things that Black judges is really smart and include that smartness in the mix and the discussions about why some of the great Black judges have been so great. I mean, isn't it also they were incredibly smart? I want to just ask you two questions at a time, if you don't mind. My second question I want to ask you is about your conclusion, which I think is very well defended in your talk, that actually, in terms of substantive outcomes, whether or not there's a Black judge on the bench doesn't seem to matter that much. That for all the reasons you identified of professionalism and reputation and precedent and so forth, you get outcomes that maybe would not be seen as biased or whatever. Okay, but what I want to ask you is there nonetheless a good reason to make sure we always have Black judges? And might that reason be go back to the idea of role models for young lawyers? So those two questions I want to talk about, intellect and role models. Your thoughts?
Thank you. Thank you so much, Professor Allen. You know, as I was thinking about Judge Higginbotham, I started to incorporate into this talk his tremendous intellect. It was, you know, blinding, so brilliant, so brilliant. And you were absolutely right that these judges were extraordinarily intelligent, and certainly that's implicit in my thinking. It's embedded in my thinking about what makes these judges great. And on the question of rationales for these judges being on the bench, absolutely. I support, and there are many good reasons to support, visible diversity on the bench. One of them that Judge Motley often cited actually goes back to how incredibly American many of these African-American judges were. She advocated diversity on the bench because she said it reinforces American democracy. It inculcates belief in equal opportunity. And the other thing I will say is that these judges, these wonderful judges and lawyers should have every opportunity that any other lawyer has. So of course, by virtue of the anti-discrimination laws, they ought to be represented in the federal courts at all levels in Congress, just like anyone else. Thank you for those questions.
Yeah. One member of our audience has raised a question about whether, just as the race of the judge in the courtroom might seem to matter, the race of witnesses in the courtroom has mattered. And the question cites a case from 1860 called People versus Hall, in which a Chinese witness was not allowed to testify against a white man. Your thoughts about whether the race of other parties to judicial matters or doesn't matter?
Yes, absolutely. I would say that it does. And there is some scholarship on this. Much of it is in the context of criminal adjudications. The race of a victim can matter very much. The race of witnesses, race and gender are tied into credibility, whether one seems like a legitimate and respectable figure to give testimony in court. Absolutely.
Your career has been remarkable, and like you, I had the pleasure of being a colleague of Lonnie Grenier, and also I worked briefly for Elaine Jones when she was as an intern when she was working at the Legal Defense Fund in Washington years ago, back in the 1970s. These are amazing people. Law professors have some of the same issues that judges have, and I want you to comment on that as a law professor. I had an experience when I was teaching at Georgetown, teaching constitutional law, of a white male student who went to the dean's office to complain to the associate dean that he felt I couldn't be fair to white people. And the only evidence he had that I couldn't be fair to white people is that day in class, I taught the three-fifths compromise. And you'll find this amusing. The dean in question, the associate dean in question, was Peter Edelman, who's married, of course, to Marion Wright Edelman, the great champion of children's rights. But your thoughts about how law professors may face some of the same issues about legitimacy and impartiality that judges face.
Sure. I mentioned starting out with your dean, Ruger, as a law professor back in 2004. And certainly my view was that there were some students, but not a majority, but a notable minority of students who noticed my race and gender, and who it made it more difficult to be considered a legitimate, competent law teacher, despite all the credentials. And before I was a tenured law professor, I was deeply concerned about this, right? Because students write evaluations that many others take at face value, right? So I remember I used to always get, or at least for some time, I would get this thing in my evaluations that I was so intimidating and unapproachable. So she's smart, but intimidating and unapproachable. And, there were giants in the legal profession on faculties with me, and they weren't getting, that same sense that they were so intimidating and unapproachable. Now that fell away, including Anita, because I learned that I had to go through extra steps in order to make the students, all of the students, again, I'm talking about a minority, comfortable with me, in order to let them know, I had to give them some love in a very explicit way, and do things that I'm sure that others did not have to do, and such is our fates.
Yes. Okay. So whether a judge or a law professor, I think pretty much all professionals of color have to face some of these same challenges. We're about out of time, but the last question I'd love for you to have a chance to address would be a question that someone has asked about whether our reaction to the finding that substantive outcomes don't matter much, whether we think that the legal system is unjust but somehow still unjust, and should we expect that once there's a critical mass of judges, of color, that things will change. That somehow, despite the fact that it doesn't seem that race matters in some direct and short-term way, over time might the race of judges matter? And I'll let you answer that as your last question.
Well, I'm not saying that the legal system is in each and every case unjust. There is a lot of play in the joints of the law. And I think that if there were a critical mass of Black judges, women judges on the bench, certainly it would create more space for those judges to speak out in the way that Higginbotham did so many years ago. And we can hope for the day when all judges, regardless, or lawyers, regardless of their background, are able to compete for those slots and help to make the law. Thank you.
Thank you, and thank you so much for your remarks. I think you've made both Judge Higginbotham and Judge Baker Motley come to life. I'm going to turn things now over to our Dean for some concluding comments. But thank you so much, Dean Brown-Nagin. That was terrific.
Thank you.
Yeah, that was wonderful. The hour flew by. I wish we had more time, and I wish we could see you here in Philadelphia. And so I would reiterate our invitation to come join us, in the spring or whenever you're able to travel here. And we would look forward to continuing the conversation. I was Professor Brown-Nagin. I was taking emails and about how good your speech was from audience members who are sitting judges here in Philadelphia, lawyers around the country, and so you really inspired us and helped keep the legacy alive of Judges Higginbotham and Constance Baker Motley, and so it's with great gratitude. Thank you, and Anita, thank you for your really wise questions and comments. And I guess, the one housekeeping matter, and I thank just a general appreciation for our staff who this went off very seamlessly as a Zoom event. A lot of work goes in behind the scenes by our events team and our IT team. So thank you for that. And I'm reminded that the appropriately, the final CLE code is justice. So enter that, and that's as good a word to end on as anything. So we'll end with thoughts of justice and an appreciation for our speaker and our commenter. So thanks a lot.
Thank you for having me.